All right, so this is our final day of our library series. And for those of you that haven't been able to make it before today, I'm Vicki Kissack. I work with Gillette Memorial Chapel, Walker Funeral Homes. We provide the library series as a reference or a resource for our community to know that funeral homes are very resourceful. And we are able to help point people in different directions. It's the act of death that brings people to a funeral home, but if our community has a good understanding of what we do, they will understand that we are, like I said, resourceful people and we can help with other things. Reaching out to the community means a lot for us. So we have a library series every year. We have went over how to write your own obituary so far this year. We have went over our website and all the resources on that. And then also just some like funeral traditions and why we do what we do for services. Last week we did that. And this week we have Rick Erb here. He and we just take our show on the road. We hit different communities and his part of the series is always the most popular. So Rick is an attorney here in town. He comes to offer legal concepts of just things that maybe we should be planning for in this time of life or any time of life. And then also he'll have a Q&A afterwards. So I'll turn it over to Rick. And at the end, I'll just visit with you about the handouts that I gave you. So there you go.
Thank you. All right, so I'm not here to give legal advice. Legal advice is what you get in a one-on-one consultation with an attorney based on your specific situation. I'm just going to visit about legal concepts, options for estate planning, things to be aware of, not necessarily appropriate for your situation because I don't know your situation. If you have any questions, be sure to let me know. Just jump right in because I'm here to have a conversation. I'm not here to lecture anybody. So I've been an attorney for longer than I care to. I never thought I was going to be an attorney in the first place. And then I didn't figure out how to get out of it. So here I still am. Spent most of my life in this corner of Wyoming. I was a coal miner in the 70s and 80s. And then
Resources
took
on
off
that.
to law
And
school
then
at
also,
Laramie in 1990, graduated in 93, and was in Buffalo for 10 years. And moved back over here in 2003, I guess, summer of 2003, we moved back over here. My wife grew up in Campbell County. So I've been around for a while, and I'm blue collar in my orientation. I'm not a snobby guy, I don't think. Big guy, but I don't think. I grew up working in a coal mine and all that goes with that. So that's my background, that's my orientation. So have a conversation. There's no dumb questions. Every question you got is a question you should ask. So when people come to see me about estate planning, usually the words that are coming out of their mouth are will. I need a will is usually the starting point for the conversation. But there's a lot more to be thinking about for estate planning than just wills. A will is a document that comes into play when you have passed away. It doesn't do anybody anything while you're still alive. It's a document by which you get to say who gets your stuff. Big picture, it's about who gets my stuff if I pass away. There's other details that become important in a will as well, but big picture, that's what a will is about. Probate is also a subject that people are largely unfamiliar with. Some people have been through them, some people have not, a lot of people have not. The purpose for a probate is to transfer the ownership of property that's titled in the name of someone who has passed away. If someone has passed away and there's an asset and they are the owner of record of that asset, it doesn't automatically retitle itself into someone else's name. Documents don't come floating down from heaven to show new ownership and stuff. So the probate process is big picture. That's what that's about. There's assets that belong to somebody who's passed away. And so the probate process is a legal proceeding in court. And the purpose, big picture, is to transfer the ownership of those assets to whoever's entitled to become the owner of them. Other things that come along in a probate include identifying who the creditors are. Just because somebody was owed money and the person who owed it passed away doesn't mean that that debt went away. The debt still exists. So sometimes probates deal quite a bit with paying off creditors. So that's part of the mix as well. Additionally, if there's a will or if there's not a will, probate is a possibility. Probate is not triggered because there is a will, and it's not triggered because there's not a will. You can have a probate either way. Probate is triggered in Wyoming when the assets that are in question, and I need to check on this because there was a bill before the legislature, and I don't know how that ended up. It's been $200,000 was the threshold for quite a few years. And there was a bill pending in the legislature this year. I need to follow up and make sure what they would do with that. They would raise that to a higher number. But if you're above that number, the only way to transfer the ownership of those assets is with probate. If we're at $200,000 or below, we can usually take care of it without a probate. Sometimes a probate is still the best way to get the job done. If there's a lot of creditors, if there's fighting in the family, sometimes the best way to get everything resolved is to have a judge hearing things and deciding how it's going to be. But when there's no controversies going on, we can take care of those estates usually without a probate. It's done by way of an affidavit saying I'm entitled to the assets for anything other than real estate. For real estate, we still have to file an action in district court and ask a judge to decree new owners. It kind of looks and kind of smells like a probate, but it's not a probate, and it's usually over in a couple of months. So the will is one of the primary documents that most people are familiar with. It. Most people have heard of a will. But other documents that are important, and sometimes more important than a will, are because the will doesn't come into play until you pass away. A lot of times, before you pass away, there's stuff that needs to be done, and you can't do it for some reason. Sometimes people get in a wreck and they get hurt and they're incompetent, and nobody else has got the authority to make decisions on their behalf unless you give them that authority ahead of time while you are competent. So for those situations, the documents that we look for would be a durable power of attorney and healthcare directive. The healthcare directive deals only with healthcare decisions, but the power of attorney covers everything other than healthcare decisions. So if you don't have one of those in place, even if you are married, this comes as a shock to a lot of married couples, you do not have the authority to make decisions on behalf of one another just because you got married. You don't have that authority automatically. You can give each other that authority by way of these documents, but you do not have it just because you got married. So that includes healthcare decisions, that includes knowing what's going on, that includes giving doctors instructions. You don't have the authority to get information or make healthcare decisions on behalf of your spouse just because you're married. And the physicians, hospitals, nurses, they can walk a pretty fine line because of federal law. HIPAA is the relevant provision in the federal law, which makes it problematic for them to share protected health information with someone who does not have authorization to have it. So that's one of the reasons to have documents like this, is because with the healthcare directive, you can designate your spouse, you can designate someone else, even if it's not your spouse, to make healthcare decisions on your behalf, to get information about your healthcare situation if you're unable to consent to anything. The power of attorney is the other document. That's for everything other than healthcare decisions, and that is a pretty important document. When it's not in place and someone becomes incompetent, nobody's got the authority to just go around doing things that need to be done, paying bills, filing tax returns. There's all sorts of things that need to be done even if you're incompetent, and nobody's got the ability to do that unless you've given them that authority ahead of time through the power of attorney. If there's not a power of attorney in place, no healthcare directive, and something happens and you're unable to take care of yourself, someone wants to help out, but they can't, the only way they're going to be able to do that is to go to court and ask a judge to appoint them as your guardian and conservator. And those are to be avoided when possible. They're not quick, they're not simple, they're not cheap to get appointed. It can be done. They get done frequently, but they can be avoided with the proper estate plan documents in place. Is there any questions so far?
Hey, Rick,
Yes,
I just
ma'am.
want to let you know, I looked up that bill that it did pass, that it raised it from 200,000 to 400,000.
It did go up?
Yeah.
Okay. So scratch that, the number is now $400,000. That doesn't simplify anything necessarily if there's still creditor problems, if there's still infighting in the family. We still got the same issues that sometimes it's going to be better to do a probate. But for those situations where there's not those complicating factors, then we can avoid the probate. So the number is now 400,000. So if a guardian is appointed, then the guardian is responsible, like a parent would be responsible for making decisions on behalf of a child. They have that kind of authority as guardian. For authority over assets, that's for authority to make decisions on behalf of the person, but to make decisions and take action with regard to the assets that belong to that person, that role is called conservator. So there are two different functions, but it's very often it's the same person doing both. Doesn't have to be. So to get appointed, almost invariably, the person who wants to be appointed has to hire an attorney to get everything going, shepherd it through the court system. But the court is going to require that another attorney be appointed at the expense of the person who's petitioning to be the attorney for the incompetent person and advocate for their interests and give the judge an impartial perspective on what they think is in the interest of the incompetent person. So by the time we all get done hiring two attorneys and getting everything shepherded through the court, it's easily more than a pretty darn spiffy estate plan to get that done. So that can be avoided if there's powers of attorney in place while you're still alive. When you pass away, the power of attorney passes away with you. Nobody's got any authority under the power of attorney when you have passed away. That's when the will kicks in. And so whoever would be nominated in the will as the personal representative wouldn't automatically have authority. They don't automatically become the personal representative when you pass away. In order to be personal representative, they would have to petition the court to be appointed. If it's named in a will, then that's typically who the judge is going to appoint as personal representative, but there's no guarantee that that's how it's going to play out. Sometimes someone else thinks that they should be personal representative instead, and sometimes they've got a good reason. Sometimes the person who was named in the will turned out to be a rat, and it wasn't realized when the will was signed. Maybe they're in prison by now. There's any number of reasons. It doesn't happen very often, but it can happen. Why the person named in the will is really not an ideal candidate to be personal representative. But until a judge signs an order declaring that they are the personal representative, they don't have any authority other than they've got the authority to ask a judge to appoint them. Once they've been appointed, then they've got authority to handle affairs, to take possession of the assets, to start looking at the mail, see what's coming in, and try and identify who the potential creditors are, decide whether or not there's any infighting going on in the family. Is there anything that needs to be try and diffused before it blows up? And sometimes there's no stopping that. Sometimes the kids have been just waiting until mom and dad were both gone to take off the gloves and go at it. And there's nothing going to stop them from having the fight that they want. I've seen some pretty big blow-ups in families where my clients said, my kids will never fight about anything. Well, you might be right, but you might be wrong. So sometimes that's part of the mix in a probate. I've heard a lot of complaining over the years about how bad probate is, how expensive it is, and there's a couple of legitimate criticisms of probate. One of the legitimate criticisms is it's not fast, and it's not intended to be fast. It's intended to be a predictable, methodical, orderly affair in which people who have a right to participate actually get the opportunity to participate. The probate's not over before they even knew about it. There's a number of things that have to be done in a probate before it's ready to be wrapped up, and it just takes time to get through some of those. I have seen probates that went on for years. Usually that's because there's fighting in the family, or there's creditor issues that we're having trouble resolving, or there's complicated asset issues that have to be resolved. But most probates can be wrapped up in a year or less, but sometimes they run long. So that's a legitimate criticism. It's not fast, but it's not intended to be fast. It's intended to be orderly. Another criticism of probate that's legitimate is that it's not a private proceeding. It's in court, and court proceedings are generally open to the public. So what does that mean? For the most part, most probates that I've handled over the years, I've never even seen the judge. We didn't have a single hearing. We submitted the paperwork. If there was no controversy, we submitted the paperwork. The judge reviewed it. Everything seemed to be in order. The judge signed off on what we did, proposed, and off to the races we went. So in most probates, I don't have a hearing, so there's no public input into it. But when you start up a probate, one of the things that happens right up front is a public notice goes in the newspaper once each week for 3 consecutive weeks saying, congratulations, there's a probate. So it's not private. The public has the ability to know what's going on. If someone's interested enough, they can go to the courthouse and pull the probate file and look at it and see what's in it. There's not a lot of secrets in a probate file. If there's a will, the will's going to be in there. There's going to be a list of names and addresses of some family members who were entitled to notice. There will be a listing of creditors, people who say that they're owed money. There will be a listing of the assets and values of those assets. So there's information that's going to be in the probate file. There's not a lot of people in the world, in my experience, that go to the courthouse and just randomly look through probate files. But there's a few people who are just wired. They wake up in the morning and they're just on the prowl for any opportunity that they can find. I don't know how they would be able to defraud anybody by knowing what's in the probate file, but it might put them onto a situation where there's maybe the probate is in trouble financially. It's got some assets, but it's got some liquidity problems, and maybe they think they could pick up some assets for cheap. So anyway, most of the information that's going to be in that probate file you can find on the internet these days. It's not like there's any military secrets or something in a probate file, but it is still a public proceeding. Even if we have a hearing, the only people that are going to show up for the hearing is the judge, the attorneys, and the parties who are having the controversy. Unless it's a high-profile family and the newspaper thinks, oh, there's a juicy story here, nobody shows up for probate hearings other than the people who are involved in it anyway. So it's not like you've got to deal with a bunch of public input in a probate. But nonetheless, for some people, avoiding probate on the basis of it being public is a motivator to try and avoid probate. And there's ways to avoid probate. There's some very legitimate ways to avoid probate. There's some unnatural ways to avoid probate. Some people are I think, a little too concerned about avoiding probate, and they make decisions that just really don't make sense to me. It's their decisions to make, but I think they're a little too concerned sometimes about avoiding probate, because sometimes probate is really unlikely. One of the approaches to avoid probate is to own nothing when you pass away, give everything away or spend everything before you die. But that is not a good idea unless you know with precision when you're going to die. And most people don't. So you can easily put yourself in a very bad spot by giving your stuff away before you pass away. But that's one of the ways that some people, they're worried about their kids having to go through a probate. And so they basically put themselves on the street and give all their stuff to the kids while they still need it. And sometimes that doesn't work out very well. There's been situations where the parents didn't know their kids as well as they thought they did. So the giving away of gifts like that does not make sense from my perspective unless you've got a lot of stuff and you're only giving away. Some people have more stuff than they're ever going to need. That's just reality for some people, not most people. But for some people, making gifts to their kids or whoever it is they want to have their stuff, making gifts is completely logical in some situations, but for some people their motivations are not well thought out, I think. But that's a way to avoid probate. Another way to avoid probate is to have a living trust. It's also known as a revocable trust or a grantor trust, settlor trust. There's different names, but it's the same thing. A trust in its essence is a relationship. The nature of the relationship is spelled out on paper, but a trust is a relationship between 3 categories of people. There's the individuals who set up the trust. They're known as trustors or grantors or settlors. Those are, again, 3 different names that mean the same thing. It's the person who established a trust. There's the trustee or trustees of the trust. That's the second category of people involved in the trust. And that's the individual who is charged with managing the assets, not for their benefit as trustee, but for the benefit of the beneficiaries of the trust. The beneficiaries would be the third category of people that are involved in a trust. So with a lot of these trusts that get set up for estate planning purposes, the people setting up the trust wear all 3 hats initially. They are the settlor, they are the trustee, and they're the beneficiaries of the trust as long as they're alive typically. There's a lot of flexibility. There's situations where it might not be set up that way, but that's a pretty common setup. And there's nothing illegal, immoral, or dark secret thing about setting them up like that. It's very common for the people setting up the trust to wear all 3 hats initially. The trust would replace the will as the mechanism by which assets are transferred when you pass away. There would still be a will typically if you've got even if you've got a trust, you would typically also have a last will and testament. But the last will and testament would say, whatever's not in my trust, put it in the trust in most situations. The trust itself is frequently set up so that if, let's just say it's a husband and wife and their situation is such that a joint trust makes sense. They don't have to each have a separate trust. They can each have a separate trust, and there's plenty of situations where that's the better way to go. But for most married couples, a single trust in which they're both the settlors of the trust makes sense. And they're frequently set up so that the spouses are the trustees acting as co-trustees as long as both of them are alive and competent. If a person becomes incompetent, they cannot serve as trustee. You have to be competent in order to be a trustee. So they're frequently set up so that if one of the spouses becomes incompetent, the other spouse can act alone as trustee. And then if one of the spouses passes away, then the surviving spouse would typically be the sole trustee. When the second spouse has passed away, they're typically set up so that at that point, the assets that are in the trust are distributed to whoever the people wanted to have the ultimate benefit of their estate. So that's frequently kids or grandkids or a combination. Some people don't have kids, some people don't have grandkids. So every situation is different. It's set up based on the family's setup. But the idea with the trust is it doesn't do you any good to have a trust and then not transfer your assets to the trust. You have to transfer the assets to the trust while you're still alive in order to avoid the probate. If you have a trust, that's a very glorious document, usually a lot of pages and a lot of big words, and it doesn't do a darn bit of good in terms of avoiding probate if you have not transferred ownership of your assets into the trust while you're still alive. So it's important to make that step. And I've seen situations where people had a trust, but they either did it themselves with a trust kit. You know, in the old days, there would be door-to-door salesmen going around selling stuff like this. Or you can find them online. There's all sorts of stuff online these days to do it yourself. But without understanding the details, it's pretty dangerous to be setting up the trust yourself because there's a lot of questions that aren't automatically apparent what the ultimate ramifications of the choices are. So funding the trust is an essential step, and frequently we can accomplish everything at the same time. When we set up the trust has to exist before you can transfer assets into it. But a lot of times we've got the information we need right up front to get everything wrapped up when we get together to sign documents. Sometimes it takes longer. Sometimes people have a lot of assets. Sometimes we've got to gather a lot more information in order to know how to retitle assets. But the notion is without a trust, you're walking through life and you're carrying your assets around in your arms. When you pass away, the assets fall to the ground. Someone else has got to pick them up. And that's the probate process and deal with them. But with a trust, it's like you've got a box, you've created a box, you put your assets in the box. If you become unable to manage the box, carry the box around, then the successor trustee steps in and takes over with that box. The trustee does not have the authority to change the terms of the trust. It says what it says in terms of who gets what. But they have the authority to manage the assets of the trust and deal with the assets of the trust according to the terms of the document that spells out their duties and who's entitled to be a beneficiary. Has anybody got questions at this point? Okay. This is going to go quick, which is fine. Again, be sure to just stick your hand in the air and just start talking. I'll shut up. Yes, ma'am.
And every state is different how it works, right? So legally, Wyoming, you have to redo all that.
Typically not. It depends on the laws of the state you're moving to. Wyoming generally recognizes the validity of estate planning documents executed somewhere else. If somebody moves to Wyoming and they've got estate planning documents, if they were valid when and where they were executed, Wyoming will typically say that's good enough. We'll give effect to that, even if it didn't meet the requirements of Wyoming law. And so when people do an estate plan in Wyoming and move to a different state, I know there's 50 different states and 50 different sets of laws, so I don't know specifically what the laws of whatever state they might move to would provide. But in general, under the full faith and commerce clause of the U.S. Constitution, states give effect to the laws of other states. So they should be just fine, but the only way to know would be to get with an attorney in that state and have them look at your estate plan and evaluate it under the laws of that state and decide if there's anything that needs to be changed. So with a trust, there's different kinds of trusts. I've been talking about a living trust, which is revocable. You can change it. You don't need anybody's permission. If you decide to change your trust, you can change your trust. If there's two people that set it up, typically you're going to have the consent of both people to make changes to the trust. Sometimes they're set up so that one of them can revoke the thing entirely without the consent of the other. Sometimes they're set up so that one can make modifications to the trust without the consent of the other. That would be unusual. So that's a living trust, revocable. There's also irrevocable trusts. The kinds of trusts I've been describing do not protect your assets. They're not intended to protect assets. They're intended to avoid probate. There's other advantages of having those trusts. But protecting assets from creditors is not a feature of most of those trusts. They're for estate planning purposes only. Instinctively, people normally think, well, I want protection from creditors. Well, okay. The way you get protection of your assets from creditors is you lose control of your assets. And I don't have very many people walking through my door saying, hi, I want to completely lose control over my assets. Would you please do that for me? That's not what's on their mind. But that's typically a feature that's going to be required. You got to lose some control over your assets in order to get protection from creditors. You don't have protection from creditors right now. If you got bills, creditors have whatever rights they've got to come after your assets. That's just the way it is. And if you put them into a revocable trust, they're still available to you, even though you now own them as trustee of your trust and not as individuals. They're still available to you, and if they're available to you, they'll be available to your creditors as well. That's not the case with an irrevocable trust. Many times, people are worried about nursing home expenses. That's on. As we get older, that becomes more of a thought process. When you're 20 years old, who's thinking about nursing home? I don't know the specific details, but I can tell you that most of the people I know who have died were not ever in a nursing home except to visit someone. So the statistics are over your lifetime. It's not likely that you're going to end up in a nursing home in a general population sense. As you get older, the odds go up. As you get older, it becomes more likely that you could end up in a nursing home. For some people, it becomes obvious that they're headed for the nursing home unless some health event comes along and takes them first. So it's not something to ignore, but it's also not something to just totally lose a lot of sleep over until you get older in years. But the government program that becomes on the hook for nursing home expenses if you end up in a nursing home is Medicaid. And Medicaid is based on needs. It's not like Medicare. Medicare, you turn 65 to get Medicare. Medicaid is not based on your age, it's based on your need. The federal government didn't sign on to be responsible for all nursing home costs for everybody. You gotta basically be out of assets before you qualify for Medicaid to start paying your nursing home expenses. Nursing home expense is huge. Unfortunately, it's a bill just like any other bill that comes in the mail, you owe it. And so until you're out of assets, the federal government isn't on the hook to pay those expenses. It's not quite that simple, but that big picture, that's the way it is. And so a strategy that some people have used over the years is I'm going to give all of my stuff to my kids, and then I will have nothing, and then I will qualify for Medicaid. That may be true, not 100%, but it may be true. When I started practicing, there was a period, it was a 30-month look back. If you were applying for Medicaid, the form that you filled out had to disclose all gifts that had been made in the previous 30-month period. And if you had made gifts within that 30-month period, it could disqualify you from Medicaid. So now you don't have assets because you gave them all away, and you also don't qualify for Medicaid, so nobody's paying your nursing home expenses, so they're going to kick you out. And so that has stretched out to now it's a 5-year look-back period. Because 30 months, people can kind of see, well, mom is slipping, and it looks like she's going to be in nursing home. 5 years, that's kind of a longer look into the future. So there are strategies for planning for Medicaid. I don't do those. There's a law firm here in Gillette that has taken on that role. They have studied up on the specializations, very specialized area of the law. And that's Tom Lovenow's office. Allison Gee in the office and Tom Lovenow in the office. I don't know if Nick Norris is doing it or not. But anyway, if you've got concerns about Medicaid, that's the office that you ought to be contacting to sit down with them and talk about your situation and your concerns. Because there's planning that can be done, but if you wait too late, it limits your options to plan for Medicaid. But statistically, most people are not going to wind up in a nursing home. Most people will pass away before they need a nursing home. But some people it's obvious that nursing home is in the future unless they pass away. So the sooner you start planning for that, the better off you'll be. It's a great thing to have long-term care insurance. A few people do, most people don't have that. It's not cheap. But some people have that, and so to the extent that they have that, then their assets are typically going to be shielded for the most part from nursing home expenses if they've got that kind of insurance. Any questions about any of that? Okay. What else would I normally talk about? So another detail that becomes very important, one of the questions that people have, husband and wife typically, when they come to see me is, what happens if one of us dies? Well, that depends on how you own your assets. The first step in the analysis when someone's passed away is how were the assets owned? As a married couple in Wyoming, you don't have to be married to be a couple, but as a married couple in Wyoming, you would have 3 different ways typically that you could co-own assets. Additionally, spouses can own assets individually. Just because you're married doesn't mean you co-own an asset. If we're looking at a vehicle, we look at the title. What does the title say? Does it have 2 names on it? A lot of times people tell me how their vehicles are titled, and I say, show me the titles. We all smile and say, well, that's not what you thought. It matters. The words on the paper matter. So what are the words on the title? Is there two names or is there just one name? If there's two names, what else does it say? And it used to be a more straightforward analysis, and then the legislature changed detail in the law a few years ago. So it matters what is there in addition to the names. If there's two names and there's nothing other than the two names, if it says or, it can say or. But the result of that is either one of the owners of that vehicle can sell the vehicle without the signature of the other, which is a little bit dangerous as far as I'm concerned. If I'm a co-owner on an asset, I don't want the other owner of it to be able to just sell it without even consulting me, but that's the way it works. But if you have and between the names, then the analysis doesn't end there. Does it also say something like joint tenants with right of survivorship? Does it say husband and wife? Does it say JTWROS, which is joint tenants with right of survivorship? Because the result of the joint tenancy or the husband and wife co-ownership is that the surviving co-owner, the surviving spouse, is the sole owner of that asset. At the moment of the other spouse dying, they became the sole owner as a matter of law. But if it doesn't have the magic words on the page, it's just got the two names, then it's, again, there's that little bit of a difference for a vehicle title. Let's talk about real estate, because that's a very common one. We would have to look at the deed by which you became the owners of it, and if there was any later deeds that adjusted ownership, we'd have to look at those too. But does the deed show both names as the buyer on the property? And if so, what words follow the names? Does it say as husband and wife? Does it say as joint tenants with right of survivorship? Husband and wife is also known as tenants by the entirety in Wyoming law. And the result of that is if one of them passes away, the survivor is the sole owner of the real estate. They don't have, it does not go through probate because of the way that they own it. But if there's only one name on there, it's not jointly owned, and that might trigger a need for a probate to deal with that piece of real estate. If it's got both names and it doesn't say anything after that, it doesn't say tenants by the entirety, it doesn't say joint tenants, then the surviving spouse still owns their 1/2 interest, but they don't own that other 1/2 interest. They might be entitled to become the owner of it. If there's a last will and testament that says I leave everything to my spouse, then they would be entitled to become the owner of it, but it's probably going to require a probate to make that happen. So what happens when one of us dies? It takes a careful analysis of the documents that show ownership. So for bank accounts, we'd have to look at what we still call it the signature card at the bank to see what are the options that were selected. Is it a joint account? Is there right of survivorship? How is it set up? The words on the paper matter. It's not a concept. It's what does the words on the document actually say. Same thing with investment accounts. Any accounts like that, you'd have to look at the document, not the statement that comes in the mail. That doesn't mean nothing. What matters is how is the account set up. And so that's not spelled out in the statements that come in the mail. Any questions about any of those? There's also the opportunity, that doesn't mean it's a good idea in every case, but there's the opportunity on bank accounts and investment accounts, life insurance, to designate beneficiaries so that if you pass away, something happens without the need for a probate to transfer those assets to whoever you want. Those can work. Those can also be a landmine. I've seen some problems with beneficiary designations. The biggest problem is people don't stay on top of their beneficiary designations. Life changes and they don't change their beneficiaries. So that can create a problem. And also, if we are working on a probate and all of the bank accounts have beneficiaries designated on the bank accounts, we can wind up in a bind because we don't have any cash in the estate to pay bills and deal with whatever comes up because all of the money went to the beneficiaries of those accounts. So we've got assets and we've got debts, but we've got no cash. So having beneficiaries designated on a checking account, for example, is not automatically a good idea. It can be if it's part of a cohesive overall estate plan, but it can also create some problems if we wind up doing a probate. The life insurance, a beneficiary designation is generally an agreement between you and that company. So if it's a bank or an investment company or a life insurance company, it's an agreement that if I die, you company are going to pay these assets over to whoever you designated as the beneficiaries. So those can fail. Those can fail gloriously sometimes. If you designated people as beneficiaries and they pass away first, then the beneficiary designation can fail. If it's set up so that it covers that as a possibility, then it's still okay. But some of those don't really have any flexibility. Most of those companies are not interested in any tinkering with their forms. Their forms are what they are. You either use their forms or you don't. But you want to stay on top of those beneficiary designations, because if life changes, then you may need to update your beneficiaries. That's a pretty common problem. Yes, ma'am.
I'm sorry, I'm going to ask you to jump back. So no beneficiaries on checking accounts. Could the beneficiary, if you set one up, could they choose to leave the money there to pay the bills? Is that, or it just gets dispersed regardless?
Well, it gets dispersed to them. They could decide to use it however they see fit. But I don't think the bank is going to say, oh yeah, okay, well, you've told us to keep it in that account in the name of a deceased person. Because they're basically going to lock down that account if the owner has passed away. So do you want the funds or not? Because you don't get them unless we distribute them out to you according to beneficiary designation. That's usually how that will play out. Does that answer the question?
Yes,
Okay.
thank you.
So another one that I've seen is a husband and wife. Husband's got a retirement plan with one of the mines and has his wife designated as the beneficiary, and then they get divorced. And then he dies. And the beneficiary designation didn't get updated. And the ex-wife is entitled to the retirement account. So that's another example of what can go wrong if you don't update your beneficiary designations. There was a happy ending in that situation, but in most situations there would not be a happy ending. There'd be somebody disappointed with the way that went. Any questions at this point?
So how much does it usually cost for having seen
That is a great question, and I don't have an answer. I understand that's like calling up the dealership and saying, hey, how much is it for me to have a car? You know, it depends on what you want, and it depends on what you need. And until you've interacted with an attorney and explained your situation, what your assets are, what your goals are with your estate plan, it's impossible to know what to recommend. And so that's why I typically dodge the question, because I just don't know. There's so many different options that people might have. It's not unusual for a husband and wife, if they're doing estate planning together with just wills, powers of attorney, healthcare directives, not a trust. It wouldn't shock me if that was $3,000 or $4,000 for everything, not per spouse, but for the both of them together. It wouldn't shock me. Every attorney, people think we all conspire. Oh, let's regulate. I have no idea what the other attorneys in town charge. I know that sometimes my practice is to meet with people and find out what their situation is and make recommendations based on what they've told me. And sometimes I always quote a price when we get done, because I know what we're looking at. And they can either tell me no, or they can say, yeah, go ahead. And sometimes people say, well, that's not as much as I was expecting. And sometimes their eyes roll back in their heads and it's not. You know, the attorneys we're not in competition with LegalZoom.com. If LegalZoom.com is what people are looking for, it's right on your computer, go get it. What most people are looking for, though, is individualized advice. And so that's where that comes in. So, but that would be probably the minimum for husband and wife, in my experience. If it's just an individual, it'd be less than that, but not a lot less than that, because it takes the same amount of time to visit about the situation and get an understanding of the assets and desires. If it involves a trust, it would not shock me if it was $6,000 $100,000 or more to get it set up. But the price, if you're talking to an attorney, you want to make sure, does this include transferring assets into the trust? Some attorneys just set up the estate plan and they handle the transfer of assets as a separate matter. If you want to hire them to do that, you can. If you don't, you don't. So make sure, if they're quoting you a price, make sure what all it includes. If you had an estate plan that included a trust, it would still also include a will, power of attorney, healthcare directive, but in addition to that, it would include transfer documents transferring the ownership of assets into the trust. And there's a number of other documents that get prepared as well in part of setting up a trust. It's real common for people who have a trust. They've got a trust, they're going to go to the bank and do something, and they say to the bank, I want to change the ownership of this account to my trust. And the helpful person at the counter says, oh, well, we need a copy of the trust. And that is not true. And in most cases, they should not get a copy of the trust. The trust is intended to be a private document, not intended to be blasted all over the place. By law, they are entitled to rely on what's known as a certification of trust or the trustee's affidavit. They're entitled to know that they're dealing with someone who's got authority to act on behalf of the trust. And so the certification of trust or the trustee's affidavit is a document that gives them their information that they need. The trust exists. The people who set up the trust are as follows, and the trustee is authorized to do whatever the trust says. But they don't need to know who gets the what, the shotgun and the clock and all that stuff. They don't need to know that kind of stuff. If somebody's been disinherited, they don't need to know that. And there's a lot of stuff that might be in a trust that maybe it's family information that they don't want blasted out all over the place. But if you've got a trust, you're very likely going to, I myself have been told I need a copy of your trust. So I've been down that road myself. But they don't, they can rely on the certification of trust for everything that they need. What else?
I have a question, Rick.
Yes, ma'am.
This is gonna be pretty specific. Okay, so I was wondering if because there's a lot of mixed families anymore. So if you have a husband and a wife who have never written anything down, not even on a hand note, written note, which I'd like for you to address later on these handwritten wills, but anyway, never had anything written down, mixed family, children are not adopted by this other spouse. The one spouse dies, do the children that have not been adopted have the same rights as natural born children born to that couple?
So let's talk about that, because mixed marriages are a lot more common than they used to be. So if there's a husband and wife, and husband's got kids, and wife has kids, and they not inherit, or they've not adopted each other's kids, even if they raised them, they're not legally the child of the other spouse unless they were adopted. Legal adoption results in that parent-child relationship being established. So stepchildren do not inherit if someone passes away. And if people don't have a will, the Wyoming statutes have an estate plan for you. Your will is in the Wyoming statutes. It might not be what you have in mind, and that's why you've got the ability to do a will, is because you don't want what's by default in the statutes. But if you pass away without a will, that's known as being intestate. There is no will. And so the statutes kick in to describe who is entitled to inherit the assets of the person who passed away. So if the person who passed away left behind a spouse and children, the spouse is entitled to half, the children are entitled to half, which can be sort of a bad situation in some families, and some families. Some people will make a problem no matter what, no matter how well things are set up, and some people will not. Sometimes things can be really messed up and the family will still pull together and find a way to make it work. Sometimes they go the other way. But that's the result so let's use an example because I've seen this one. Husband and wife, husband owned the home. Wife was not a co-owner on the home. Wife and children were left behind when husband died without a will. So there's a house, and in this case, the kids were very young. Mom was not old, dad was not old, but dad died. And so now mom is going to end up being a co-owner with the kids. She's still got bills to pay, she's still got a mortgage payment to make, and she's gonna be paying the whole thing herself. The kids aren't gonna be coming up with any money for 15 years or so. And so that can be a very unideal situation. And so if there was a will that said, I leave everything to my wife, she would have been entitled to become the owner of that place. But as it was, she wasn't even an owner at all. So she was gonna end up being an owner of a 1/2 interest along with the kids. So that's an example of what can go wrong when there is no will. But so the Wyoming statutes would apply if there's not a will and there are assets that need to be dealt with. Those statutes do not apply if you co-own something with a right of survivorship. That decision, that analysis, that legal transfer of ownership happens before we even analyze whether or not there's a will. So if you co-owned everything, if you actually co-owned everything with a right of survivorship or as husband and wife, and one spouse passes away, the will doesn't come into play. Everything became the property of the surviving spouse because of how it was co-owned. But if that surviving spouse then passes away, then whatever assets he or she has, the will would govern, or the Wyoming statutes that govern when there's no will would define who becomes the owner of those things. So I've seen this happen as well. The husband and wife leave behind I love you wills, and they say, if I pass away, I leave everything to my wife, I leave everything to my husband. Well, that's fine. And then husband passes away, his kids inherit everything. Wife's kids inherit nothing because everything went to the husband while he was still alive. And his will leaves everything to his kids. So that's a problem with some estate plans I've seen. So if you're setting up an estate plan, and let's just use the example of will, and you've got a mixed marriage like this, one of the things that has to be discussed is, do all of the kids inherit, even though half of them are not mine? Do they inherit as though they were mine or not? We can wind up in a situation when dealing with husband and wife doing estate planning, and it's something that should be discussed with the attorney in every situation when they're doing joint estate planning. There's the potential for a conflict of interest. Just because a husband and wife walks through the door together doesn't mean that they're on the same page. And that's okay as long as there's no secrets. And so there's the potential for a conflict of interest to develop, even if it's not apparent, when working for a husband and wife. One of the problems that you can have is husband and wife both do estate plans and they're fully on board with how they're set up, and my kids are going to inherit right along with your kids. Everything is set up just fine, and one of the spouses passes away, and then the surviving spouse says, oh, well, now I'm going to do a new will, and I'm not going to leave anything to my husband's kids. And so there's the potential for future changes to the estate plan, even though everybody's on the same page going into it. Life goes on, and if somebody passes away, sometimes people remarry. Sometimes they develop a new life after the fact, and so just because you've got an estate plan doesn't mean the surviving spouse is going to stick with that in the future. There's ways to try and lock people into that. I've seen joint wills. One thing that I learned with precision in law school is don't do joint wills unless you can convince me that you're going to die at the same time, and you can't, so don't try. But unless you're going to die at the same time, you don't need a joint will. A will says, when I die, here's what happens. Not when we die, here's what happens, because we don't typically die. It can happen. People go down in the same plane sometimes, same car when there's a wreck, but it's pretty rare that it happens. So it's important to have those conversations, but one of the situations that cannot happen is if I meet with a husband and wife and we've had the discussion and I've got all the information I need, and then I get a call later from the wife, hey, don't tell my husband, but I'm sorry, you just conflicted me out because I've got a duty of loyalty and a duty of confidentiality to my clients. And I've got a duty of loyalty to the other spouse to disclose what I just heard. I got a duty of confidentiality, the one that just said, don't tell him. And so it creates an unhappy situation. So it's important to make sure everybody's on the same page. They don't have to have the same plan. His will can say what he wants it to say, hers can say what she wants it to say, as long as everything's on the table and we all know it. And that's seldom how it works out, but every once in a while they got different ideas. And if I die first, here's how it is. And if you die first, here's how it is. So it's important to figure those things out when you've got a mixed marriage, because if you've got a mixed marriage, the stepkids are not going to get anything from the person who passed away unless there's a will. The will trumps the statutes if the will is valid. But that's another thing we should talk about. Just because there's a document that says last will and testament, and it can really look impressive and say a lot of neat stuff, it's not a last will and testament unless it meets the requirements of Wyoming law to qualify as a last will and testament. And so if it's not been executed in accordance with Wyoming law, then it's not a will, even if it says it's a will. So what does that mean? Well, it's got to be witnessed when you sign it. It's got to be witnessed by two disinterested witnesses. So they're not related by blood or marriage typically. They're competent adults, and they're not attesting to what's in the will. They're just attesting to the fact that the person who signed the will seems to be a competent adult, that they seemed to know what they were doing, that they seemed to be doing it voluntarily. Nobody was forcing them to sign the document. So that's the purpose of the witnesses. There's typically also going to be a notary present. The notary is not a witness. The notary is there to sign as a notary, but also to swear people in. I swear these things are true, because the document itself contains some language that would be the equivalent of an affidavit. I swear these things are true. So that if we have to go to probate the will, we don't have to call in the witnesses to say to the judge, yes, I was there, I saw the document being signed. The document itself, it's called a self-proving will. It proves by its own internal contents that it was signed properly. So if it's not signed properly, if there's somebody who would not qualify as a witness who acted as a witness, we're probably missing two witnesses. We might have one witness, but we don't have two, and it doesn't qualify as a will. So it's important for those things to meet all the requirements in order to be a will. So it's got to be properly signed. It's got to be properly notarized, properly witnessed, and then it can be a will. But that doesn't mean that it's free from challenge. People still have the ability to challenge the will later on. If we go to probate a will, part of what we have to do is send a copy of the will to everybody who would inherit under the terms of the will, and everybody who would inherit if there was not a will. And so that frequently would include situations where someone's been disinherited. They got 5 kids. That little rat is getting nothing because of the way he's treated me for the last 10 years, whatever. Well, that little rat might think, well, I don't like what the will says. I'm going to challenge the will. I'm going to get my share. And so that's why we send it to people who would inherit if there was not a will, in case they think there's something wrong with the will. But it's not a legitimate challenge to a will to say, it does not leave me enough stuff. I should have inherited more stuff. That's not a legitimate challenge to the will. A legitimate challenge to the will would be that when the person signed the will, they were incompetent. And sometimes that could be. Sometimes it's not entirely clear whether someone's competent or not. A lot of people who are coming and going in competency, they get up in the morning and they're right on top of their game, and by the afternoon they're really having a little trouble tracking. If they were competent when they signed the will, then it should stand up. If they were incompetent when they signed the will, then it should not stand up. And it's hard to say how that's going to be proved, because there's no bright line, there's no light that goes off that says incompetent. You know, it's a question of what do the witnesses who were there recall, what do the medical records show, have been diagnosed with Alzheimer's 2 years prior to that time, what proof is there? So if someone wants to challenge it, in some situations it's not entirely clear that the person was competent, because it's not the job of a lawyer to diagnose incompetency. I have to size people up when we're doing documents. If I think someone's incompetent, I'm going to be pretty hesitant to get involved in drafting documents. But in terms of an overall diagnosis, there may be other witnesses. I don't go beating the bushes. I don't start calling the doctors, hey, what do you think? Is it competent? That's not the role of an attorney to draft the documents. If I'm satisfied that I'm working with someone who understands what's going on, I'll move forward. But if someone later on decides to challenge it, then everybody who might possibly have useful information about whether or not a person is competent could be called in as a witness. So competency is one way to challenge a will. Another way to challenge a will would be that it was the result of fraud. Somebody signed the document, but they did not know it was a will. They were told that it was something else. Well, that might call into question the competency if they're doing that. But so fraud, if someone was deceived into signing a will, that could be a basis for challenging the will. Another one is and I've seen this a number of times, undue influence. Somebody, a common scenario would be someone who's getting up in years has trouble getting around. They have trouble going to the grocery store, have trouble getting to the doctor for appointments, and some helpful person comes into their life to start making life easier for them. And that's fine. It's good to be helpful. But sometimes that helpful person makes an appointment for the other person with the helpful person's attorney to draft a will to leave everything to the helpful person. And, you know, that on its face can look pretty suspicious, especially if it's not even a family member, somebody that they didn't know until 2 years ago or whatever. A girlfriend, a husband passes away, he's lonely in life, and his girlfriend moves in and starts helping out. So undue influence, if you don't sign a will that leaves everything to me, you're on your own. You can figure out how to get to the store. You can figure out how to get to the doctor. If you don't do that, you're on your own. Well, that's undue influence. If the person who signs the will is leaving it to someone they would not ordinarily want to leave their assets to, that's undue influence. So that's another legitimate basis for challenging the will. So those are a possibility. I haven't seen very many of those over the years in a probate, but that probate process is where that challenge to the will would come into play. You have the ability to do your own will. It's called a holographic will in a generic sense. Wyoming statutes recognize the potential validity of a holographic will. But in general, those have to be all in your handwriting. You've got to handwrite everything. There's been situations where people bought a form at a business office store or something. There's a form for a will. And they bought the form and they filled it out and they signed it. Thank you very much. And they think they're done with it. That is not a will. The handwritten portion can be evaluated to determine if there's enough in the handwritten portion to make out what the person intended, but we would have to ignore all of the pre-printed stuff. If it was properly signed in front of notary and witnesses, then that's not an issue. But if it's just a fill-in-the-blank form and all I did was fill in the blanks, then everything that's pre-printed on that form is ignored. So a holographic will has to be entirely in your handwriting. And there's a lot of details that can be important in a will that most people they're not familiar with what should be in a will. So they either leave them out or they use incorrect legal terminology sometimes. But you do have the ability to do a holographic will. I would say that is risky beyond description. That'd be risky, but it's possible. I've seen a holographic will one time, and there was litigation over that one. So anyway, the reality is that you can do a holographic will, but they are pretty darn rare. And one of the reasons is because they're problematic. Any other questions that address?
It did,
Okay.
yes. It's frustrating because I know a lot of people who have mixed families and have been mixed families for a long time, and they just don't think it's important to get a will or an estate done, and it's just tragic to see that a freight train coming down the road.
Yeah, and I've seen a number of situations where there's a mixed family and everybody seems to be getting along just fine, and then one spouse passes away, and then all of a sudden the lines get redrawn. in most cases, the lines get redrawn and new affections develop. And people who are not my kid, I no longer cared much for you in the first place anyway. That's just the reality of nature of relationships. Relationships change over time based on other relationships sometimes. Anything else? Yes, ma'am.
I think I know the answer to this already, but if I have a will that's properly executed in Wyoming and I sell my property, move to another state, does that follow me? Or do I
Probably.
need to do some updates?
Yeah, probably. The only way to know is to get with an attorney in that state, have them look over your documents, let you know. In Wyoming's got a law that says if it was valid, when and where it was executed. So if it was a Colorado will and it met the requirements of Colorado law, even if those don't match Wyoming's. If it was valid in Colorado when it was signed, then Wyoming is going to give effect to that. So, but I don't have any way of knowing what state you move to. The laws of that state are going to be different 50 different ways.
Me either.
Yeah.
Is there a way to skip generations to try to save from estate taxes?
Yeah, so let's talk about estate taxes. Estate tax, that's not state, that's estate tax, is a federal law, it's a federal tax. And most people are nowhere near needing to worry about estate taxes. Some people are. And I don't know yet what the number is going to be. I should have looked at that and refreshed my memory on that number. It's quite a few $1 million is right now the threshold before estate taxes are a problem. And I wish I'd looked. I think it's around 18 million right now. The reason I waffle is because right now it's set at the end of this year, it's set to dial back to a few years ago when it was 6 million, I believe. 6 million is what it was before there was a compromise between Congress and the president. And so it was ratcheted up quite a bit the last few years. And unless they enact new laws, then it's going to go back to 6 million indexed for inflation. So it could wind up around 8 million or so. It's not clear until inflation is factored into it what that's going to be. Most people are nowhere near that threshold, but for people who are, when the estate tax kicks in, it kicks in pretty hard. It's, I think, 45% right now is what the tax, it used to be 55% when it kicked in. So it was a lot lower threshold. So what it amounts to is every state, every estate technically is taxable, except that we all have a credit with the IRS that pays that tax up to a certain threshold. And most of us are nowhere near that threshold, so it never means anything. But that also includes lifetime gifts. So for people who make lifetime gifts, that eats into that credit if you're above. There's an annual exclusion amount that you can give. Again, I should have looked at that number to refresh my memory. But I think it's around $18,000 or $19,000 that you can give each year to as many different people as you want without eating into your credit exemption amount. So for some people, having a regular gifting program makes sense to try and shrink their estate because they're going to have more than they're going to need anyway. And so sometimes having a gifting program makes a lot of sense for some people in order to reduce the estate tax when they pass away. Each spouse has the ability to take full advantage of that exemption amount, but that is lost if they have I love you wills, which leaves everything to the other spouse. The other spouse winds up the owner of everything, and they only get one exemption amount. So if estate taxes are a concern, that's going to dictate a more complicated estate plan in order to try to avoid the estate tax issue. Any questions about that?
Is estate tax different from inheritance tax?
There's technically no inheritance tax, and there has been over the years, there's been an inheritance tax. Inheritance is a tax that's paid by the recipient of the asset. They inherited something and they have to pay a tax. Wyoming does not have an inheritance tax. Some states do. Wyoming does not. The federal estate tax is not an inheritance tax, it's a tax on the estate. The estate has to pay the tax. If an estate tax is owed, the estate pays it before they transfer assets out to the beneficiaries. So it's going to be based on the total value of the assets that the estate has as to whether or not it's taxable. Another delay in probates that I've been running into for several years now. We can't wrap up a probate until we have filed all necessary tax returns. And sometimes we've been waiting on the IRS. I've got one estate that's been open for 5 years, waiting on a tax refund that is very clearly owed, and the IRS will not issue the check. Why will they not issue the check? No explanation. I personally, my wife and I were owed a refund 4 years ago. We finally got the refund check after January 20th. There was no question that the refund was owed, and it was not tiny. It was a lot to me. But the IRS would not respond to our CPA. They were not responsive. I don't think they were working. I think they were all remotely watching TV or whatever. So one of the problems we've been running into is dealing with tax issues, and the IRS doesn't timely generate new forms. So the forms for tax year 2025, the 1040 form hasn't been prepared yet. It won't be needed until January anyway, so what are you worried about? So sometimes we're sitting there twiddling our thumbs until a tax form has been generated by the IRS so that a final tax return can be filed. Because we can't file the final tax return until there's a form. So that can be a hang up that keeps probates open sometimes. But normally we're not going to delay most of the distributions. We'll hang on to some of the funds in case we're not sure what the IRS is going to say is actually owed. But there's a number of reasons why the states have to stay open in payment of taxes and filing tax returns as well. I'm running out of stuff to talk about. Anybody?
Why don't you think Wyoming has an inheritance tax? I mean, is that common through the United States? I'm glad it doesn't. I'm just curious.
We used to get a share of the federal estate tax. So the federal tax would be calculated. Wyoming would be entitled to a portion of that, was how it used to be. And then the IRS changed their mind and said, "No, just kidding, we're going to keep it all." And so Wyoming has not received a portion of the federal estate tax for quite a few years now. And for whatever reason, the Wyoming legislature has not changed anything to fill in that gap.
Good.
Yeah, good.
Raise your lights over the internet, here it comes.
All right, well, I got a handout for you that just reviews some of the concepts that we've talked about. Let me take a look at that right quick and make sure there's maybe something I've forgotten about.
Usually we have way more questions.
Yeah,
Kind of a quiet group today.
very good. Oh, there is one other thing. There's also what's known as a transfer on death deed. It's for real estate, and it's a way to transfer ownership of real estate after you have passed away without probate. So the transfer on death deed, in essence, it says when I pass away or when we pass away, the property then belongs to, and then they name whoever they want to have it, usually the kids. And so then that gets filed, it's got to be filed with the county clerk while they're still alive. The transfer on death deed cannot be filed after they've passed away. It's got to be while they're still alive. And that is a pretty useful tool in some situations. The first one I ever did, it was a disaster. I misread the family, and it was a family issue, not a document issue. So they can be a good idea in some situations. You're not universally a good idea, but that's a way to avoid probate for that asset. But that doesn't mean that it avoids all problems. In the case I'm talking about, the first one I did, I was called by someone to go to the ICU and meet with a fellow who they said is going to be dead by the end of the week. Can you come do his estate plan? I don't know. I'll go visit. I got there and the family was all in the ICU. He was still competent. There was no question about that, but he had a health issue that was about to take him out. So he was competent. The kids were all there. He was a single guy. Their kids are all adults. And he wanted to leave everything to 7 kids in equal shares. Not a problem. So I did a transfer on death deed so that that's not part of the $200,000 commutation. There's no real estate to deal with in the probate. And he passed away, and one of the kids hooked onto the 5th wheel, loaded it up with stuff, and headed for home. And so all of a sudden we realized there's a rat in this family. So they're not automatically a good idea. And they're also not a good idea if you've got a lot of kids, but especially if they don't get along all that well. Because what you're doing is forcing them into a business relationship and saying, here, you sort it out. Well, the way it gets sorted out sometimes is a lawsuit. So it's not automatically a good idea, but for those situations that it is a good idea, it's a great way to avoid probate for the real estate. And so the transfer on death deed, we've had them in Wyoming for a while now, I don't know, 10 or 15 years. I can't remember when it was first enacted. But that's a useful tool. I've had a lot of people come to me over the years. Usually it's a widow who says, I don't want my kids to have to deal with the probate. I want you to put the kids on the deed with me so that when I die, it's their place. And that, I won't do that with 2 exceptions over the years. There's been a couple of situations where I did, but what you're doing is taking your most valuable asset and losing control over it. You have just made your kids the co-owner on your home. And if one of them winds up with creditor problems, congratulations, those are your creditor problems too, because that's now their asset and their creditors can reach that asset. Or if you say, I think I want to move to Arizona, and the kids say, sorry, I don't think you can move to Arizona. We're not selling that house. You've lost the control over the house. So I just don't do those for nearly everybody universally. But the transfer on death deed is useful because you can revoke that. You can change it. You can change your mind. If you're still alive and you've done a transfer on death deed, you can change your mind. You can still sell the place. It's still yours. The kids do not co-own it. Until you've passed away, they don't own any interest in it. So those can be a great tool in those situations where the family is set up to where it's not going to create problems in the future. Okay, any other questions? I'm going to hand these out. You can put them in the trash. There's a trash can. Or you can do with them whatever you wish.
So back to your question, your comment about the creditors and the,
Yeah.
so parent dies, 5 kids have ownership of the house. Would a creditor issue cause the house to have to be sold to resolve that creditor issue? Is that what you're?
So let's back up to the starting point. You talking about creditors of the person who passed away?
No.
Creditors of the kids?
Yeah.
And so is this a situation where the ownership of the property is now vested in the kids?
Yes.
And one of them has creditor issues?
I don't know, maybe. I mean, not that I know of, but if they did, I guess.
If they did, yeah. So a creditor of, say there's 5 kids and they've all got a 1/5 interest in it. The creditor could only attach their 1/5 interest in the property.
But it still might force the sale.
It might, and if they want to try and force the sale to satisfy the debt, then they could try and do that. Usually if that's coming down the pipeline, the family's going to figure out a way to get it paid off and get rid of the creditor.
Okay, thank you.
Anything else? Well, thanks for not throwing anything at me.
We're not done yet.
All right, well, thank you, Rick, very much. So I did give you a couple handouts if you're interested. Well, let me tell you what I do with the funeral home. I do pre-planning. That's why it's a big deal for me to bring in people to talk about all sorts of different things of pre-planning, whether it's will or estates or anything like that. So I gave you a paper. Some of you already have kind of seen me, some of you haven't all looked out. But if you're interested in sitting on me, it doesn't cost anything. We just get a plan done so that your family's not caught flat-footed on what you want for your final wishes. And And then we talk about if you want to fund it, you can prior, but mostly it's just about getting details down of what you want beyond just burial or cremation. That's what I do. I also do aftercare. So if you yourself or you know someone that has lost a loved one recently that needs somewhere to go to just visit with others that are going through the same kind of grief, we have a meeting the first Wednesday of each month at 10 o'clock at the Walker location. So I would just want to throw that out there because grief is difficult and it's really, really hard to do alone. So my goal is that nobody walks through grief alone. Have yourself or someone join us. And then I gave you this handout. This is just something that I do for pre-planning as well. You can just look through it. If it's something that interests you, you can let me know. My mom died in January, and just to give you a little bit of story about how all this pre-planning comes to be, is my mom did both her and my dad's pre-planning with me. Because dad didn't want to talk about it, still don't want to talk about it. So mom always just took care of stuff like that. And when they went and did their estate planning, it was up to dad. He would not have went. It's just not something he wants to talk about, but mom really wanted it done. Never, ever, ever thinking that she would have been the one to die first. My dad has chronic stuff. So beyond having this away from home assurance that my parents both had because mom wanted it, they did have the estate done. And I'll just tell you a personal story that, so my parents and I are really close. I am their child that stands in the gap and helps take care of them. Not that they needed a lot of it, but they live about 450 yards as a crow flies from me. And they took care of me for a lot of years of my life, so it's part of what I do now. But we were on our way to Colorado in the car, and my mom was being life flighted down there. And all of a sudden it hit me. I had told the people at the hospital when she had a heart attack that she was a full resuscitation. And mostly I had said that because in the moment of it, they're going, does she want resuscitation? Is she a DNR? And they're just asking me after, like, full, she wants everything. She wants everything done. She wants everything done. In my mind was from conversations in my life that I'd had with my parents. But when we're driving down there, not knowing what we're gonna meet up with when mom gets there, or when we get to mom, I immediately remember they have it written down in their estate planning. So it's like 10 o'clock at night. I don't wanna tell dad that I'm now concerned about it. We're not saying anything between the three of us. We're on winter roads. It's scary. It's just a traumatic situation. So I start texting my daughter-in-law by the phone on my phone, the line of my phone. I need you to go and get a document out of the safe. And she's like, okay, right now, because the girls are sleeping. I'm like, yes, right now. I leave the children by themselves, they're fine. And I'm like, this is crazy. I don't want Rick to hear me saying this, but I'm like telling her by text how to open the safe because she don't know how to open the safe. But I'm like, in my mind, I'm like, did I do the right thing? Did I tell them correctly? When we get to Colorado, am I gonna know that I know that I know that she's supposed to be resuscitated? And so anyway, she gets it out. She snaps a picture of the Advance Directive from her estate planning and sends it to me. And it was just like, it was right. I had told them correctly that it was okay to bring her back. So for your children, of those of you that have children, and for your grandchildren, if you can't bring yourself to get the plans done for you, I will tell you, as a child, do it for them. Because in those moments, it's tough, like just to know that you're doing the right thing. And just that little piece of paper that they did a year and a half earlier, or 2 years earlier, or whatever, it brought so much peace. I never even had to tell dad that I was frantic. I still haven't told dad to this day that I wasn't sure, and I had to have this document found. So when I ask the kind of questions I ask of Rick, it's mostly because of just life and things that I'm walking through and trying to figure out. But I really do want you to know that the simple little bit of planning really saves a lot for your family in the future. And all of you are here because you're interested, like how to be a planner. So take your interest and put it into a document and save your family from being caught flat-footed.
I'm just kind of curious how how's the hospital supposed to know what that documentation says unless you've got it?
Right, so I thought they would ask me for it down there. And that's a really good question. So I actually had her snap a screenshot of the, the plan, and then it was official, and if I had to, I was gonna show them, on the phone. But the hospital here never asked for, do you have that document? They were just like, and in the moment, like she just had a heart attack, and their nurses are flying, and they're gonna ask me what to do. I would assume that would be a document that I could provide, I'm sure a hospital, but they wouldn't just stop the procedure, I don't think, I guess. But I could provide a document like that to a hospital. I mean, how would that work?
Yeah, so
How'd they ask me?
it's not a bad idea for the healthcare directive, I'm not saying for the durable power of attorney, but for the healthcare directive, it's not a bad idea to get a copy of that to whoever your doctor is or wherever the hospital is you're most likely to be treated at. Because when an emergency comes along, that's a really bad time to go looking for a document. So if you've gotten it to them ahead of time and said, here, please make this part of my chart, theoretically, they'll be able to pull it up and they've got it. I don't think there's been a time I've gone to the hospital to check in for anything that they didn't say, do you have a living will? Do you have a healthcare directive? They ask those questions. And so if the answer is yes, then it's not a bad idea to provide it. You don't have to, but it's not a bad idea to provide it to them so nobody's got to go scrambling when there's an emergency.
Yeah.
That's not true for the durable power of attorney. That's a separate analysis, and sometimes you want to sit on those documents.
Yeah.
So if you don't have a DNR, will they work on you? I mean, if you haven't told anybody that you do not want to be resuscitated, will they
Yeah,
work on you?
If they don't have a copy of your document, they don't have proof that someone else has got authority to make decisions. And I know that they're doing the best they can. They're trying to take care of people. They're genuinely trying to take care of people. But it might get to a situation sometimes where they get a little uncomfortable taking directions from someone that they have never seen any documentation on. And so if you've got a DNR, that's a separate matter. The term gets thrown around, but that's kind of a specific form at the hospital form typically. And sometimes it's hard to get a DNR form from the hospital, I've discovered over the years. But the healthcare directive would be a document in which you've given your thoughts on how you want to be treated if you can't give explanations. Even if you've got a healthcare directive, if you're still competent, they're going to be talking to you. They're going to be getting instructions from you. They can't treat you without your informed consent. So they're going to be giving you pros and cons of anything that they're proposing or trying. And you have to consent if you're competent. If you are incompetent, that's when the document becomes pretty important. It doesn't use the term DNR in my experience. It says, I want to be kept alive as long as possible, or I don't want to be kept alive under the following circumstances. Some people keep me alive as long as possible, and when you run out of money, go borrow some money and keep me alive some more. But most people don't have that, and there's no right or wrong. It's a personal preference. And so for those some people are sort of in a hurry to have the plug pulled in. I understand you don't want to be kept alive forever, but let's give this a little bit of thought. Under what circumstances do you want to be let go? And so common circumstances would be, I have an incurable and irreversible condition which is going to result in my death in a relatively short period of time. I can be kept alive, but don't do it. It is one area. So what would that be? Maybe you're bleeding out and they've got a few bags of blood that they can put them into you, but you're going to be bleeding them out and they're going to run out of blood at some point. That could be an example. A medical professional could give you a more informed range of possibilities for that. But that's one. Another one would be, I am in a coma and the doctors have decided that it's unlikely that I'm ever going to come out of a coma. Another situation would be basically a vegetative state. I'm a vegetable and the lights are on, but nobody's home. My eyes might open up, but I don't recognize anything coming or going. I don't know what's going on. What do people honestly know going on around them? I don't have any idea. There's all kinds of people who have thoughts on what it is people actually know when they're in that condition, and occasionally you hear somebody talk about, well, I was in that condition and I heard everything they said about me. Keep your mouth shut unless you're saying nice things. But, so those are situations that come into play in terms of deciding whether or not to resuscitate. But the DNR instruction is kind of, my experience, is kind of a specific instruction with the hospital. A DNR is something that's usually going to be at the hospital on their form.
Yeah, for sure. I can only tell you from my personal experience with Mom is she wanted everything done possible. She had made that very clear. And when we got to Colorado, they put a vent on her here. She never woke up again. And that we had to Dad had to make the decision the next day. So, yes, it is a very difficult position to be in, but also I'm thankful that I did have some point of reference, that it wasn't just me wanting or not wanting to let go, that was really what she wanted. So, anyway, that's really what I have for y'all today. Again, please take handouts. If you fill out the family planning form, I will contact, if you say that you'd be interested in coming in and visiting with me about getting your final wishes plan, I will contact you and we'll sit there and tell each other stories. Usually it takes about an hour, but if we tell too many stories, we're bumping up over an hour. So I love stories. Otherwise, this is the end of our library series for this spring, and we really just appreciate you guys coming, and let us know if you have any questions. All right. You're very welcome. Thank you for sharing your time.
All right,